Hear ye, hear ye. The court is not in session. The Honorable Justices Bacharach, McKee, and Celia presiding.
You may proceed, counsel.
Good afternoon, Your Honors. Lisa Faye Petak, representing Petitioner, the United States. With this court's permission, I would like to reserve 5 minutes for rebuttal.
Yes, permission granted.
The Mount Soledad Memorial has stood atop Mount Soledad for 100 years, and over the course of its history, it has come to serve...
We know the facts of the case. Why don't you help us understand why this jurisdiction here, why this standing?
Absolutely, Your Honor. The petitioner, the United States, contends that respondents lack standing to bring this case because, as this court held in Valley Forge, a person's injury must be personal to them and
If they don't have standing, who does?
The person who would have standing, Your Honor, is the man or woman, perhaps, who mows the lawn around this particular memorial. As Valley Forge held, a mere psychological disagreement.
There has to be an Establishment Clause violation under any test. There has to be an economic impact. It sounds like you're saying if you stop mowing the lawn because of religious objection, you can show the kind of injury that will give you standing, but then you're merging economic loss and establishment standing, which I don't get. I don't follow you there.
Of course, Your Honor. As this court has held in Valley Forge and in subsequent cases, the sorts of injuries that can qualify for standing in the Establishment Clause context can include anything that makes you feel as if you are not a full member of society or that you are being coerced into a certain behavior that violates your own idea of your own personal religious beliefs. As this court has held in Schempp, the idea that within the classroom you cannot be expected to ignore school prayer, or in...
But coercion can be negative in its nature. It can mean that you're being compelled to refrain from activities that you would ordinarily engage in. Isn't that so?
Yes, Your Honor.
And you have at least one plaintiff here, a Jewish war veteran who has filed a declaration saying that he had historically taken visitors to Mount Soledad, and he is now, because of his feelings about the memorial that is there, has ceased that behavior. Why isn't that a sufficient injury?
For two reasons, Your Honor. First off, the plaintiffs, now respondents in this particular case, have alleged an injury that is they disagree with the idea of a particular religious symbol being on federal property. Valley Forge has held that the psychological disagreement and the desire...
There was no direct connection, though. That was just kind of a generalized claim that was brought. It wasn't someone who was directly involved with the transfer of property as we have here.
Correct, Your Honor. The other reason why the respondents here lack standing is because this court has never gone so far as to say the lack of enjoyment of a park is enough to confer standing. While lower courts have...
Why wouldn't it be? If you enjoy a park and you stop being able to enjoy the park because of a religious symbol that the government is maintaining, has put there on government property, a very prominent symbol, and you feel that offends either your religion or your non-belief in religion, why wouldn't that be enough? And if it isn't, why shouldn't we use this case to declare the fact that that is enough for standing?
The reason, Your Honor, that would be not enough for standing is because it broadens the number of people who could come into court and make an Establishment Clause claim.
You're saying it's too much liberty? Is that what you're arguing?
Yes, Your Honor. That it would amount to more of a generalized grievance with any particular park that someone could have a problem with.
Well, but you could say that of the standing that we've recognized in the environmental cases, right? Where we have said that standing is conferred upon anyone who's a regular user of property, all right, on which government creates or permits an environmental hazard.
Correct.
I don't understand what the difference is if instead of an environmental hazard, government creates a moral hazard by putting up something that reasonably signifies to me that it is an expression of the government's support for a particular religion to the exclusion of others.
Your Honor, in the environmental context that you had just alluded to, the plaintiffs in those cases were alleging an injury that they were going to be denied access to clean air, clean water, or in other cases where standing has been denied the ability to visit endangered species.
Yeah.
In the
So,
First
so
Amendment,
being denied access to equal recognition of the contribution of a non-Christian war veteran to the defense of his country is somehow less deserving on some scale than being denied clean air or clean water?
no, Your Honor. The way I would frame this is the fact that under First Amendment jurisprudence, while this court has held that there is a more broad idea of what constitutes a personal injury, this court has never gone so far as to say that denial of a parkland that is not near a body of like, for example, in Van Orden, where it was near the Texas State Courthouse, or state capitol.
Isn't that a merger of standing and the underlying issue of the Establishment Clause?
Yes, sir.
Before we can approach the issue of whether or not it is, there's an imprimatur of government, I think we have to address the issue of standing. How can we analyze standing based on your argument with regard to whether or not it's close to or far away from government buildings? Why is that relevant to standing?
It is relevant in the sense that it would be, you'd be opening up the courthouses for generalized grievances if you allow for parkland across this country to be open to Establishment Clause challenges. As this country becomes more and more diverse, if someone, for example, does not feel that a Armenian genocide memorial with religious symbols does not represent them, they would have the ability to come into court when they cannot necessarily show an established personal
Well, if
injury.
the government erected a very large religious Armenian sign, as big as this cross is, on a piece of land, they may well have a very legitimate claim. If we adopt the rule that you're advocating 10 minutes ago, how would it be applied? If there's some kind of geographic determinative here, is 1 mile too far? Is 2 miles too far? Is it 100 yards? How would we enforce such a rule? How would you apply such a rule if it turns on distance from the symbol?
It's not about mileage, Your Honor, but so much as whether or not someone feels as if they're being denied access to the state and the resources that it has to offer. Instead of saying that Establishment Clause violations only exist on courthouses, instead it's to say that someone must face a personal injury, which is one reason why I said that a maintenance worker who works at this particular site or at an Armenian genocide memorial would have standing to be able to challenge due to the fact that they cannot avoid it.
So if you follow your argument to its logical conclusion, none of these plaintiffs would have standing, or anyone else for that matter, other than the man who mows the lawn, would have standing to challenge this memorial if it was erected at the gates of Yellowstone National Park.
This is the logical conclusion of my argument, Your Honor. Yes, there will always be a plaintiff who will be available to be able to challenge.
But the millions of Americans who want every year to visit Yellowstone National Park and have no other connection with that park, none of them would have standing. It would simply be the fellow who mows the lawn around the memorial, or someone who was in his type of situation.
That particular plaintiff would be able to show that there is an injury that they cannot
Yeah,
avoid.
but the millions of other Americans wouldn't be. They would be perfectly all right to deny them the use of as historic and well-traveled a facility as Yellowstone, all right? Simply because they don't have any direct injury, or their only injury is this moral offense, which you seem to denigrate.
I do not mean to denigrate their moral offense, Your Honor, but merely point out that there is a distinction between moral offense and a desire for the separation of church and state, which each of the respondents here have pointed out in their complaint is their primary reason why they believe that the Mount
What is wrong with that? If they didn't have that desire, obviously they might have a personal problem with it, but they wouldn't go to all the trouble of trying to vindicate that belief.
Valley Forge, as this court held, says that the psychological consequence of disagreement and the desire to enforce the laws of the United States, whether or not you believe them for an action that you believe to be unconstitutional, is not enough to create a personal injury.
If that's all there is, all right? But then we have other cases which go on to say, but if that also produces an alteration in an individual's behavior, the individual whose behavior is altered has standing.
Correct, Your Honor. This court has not gone so far as to say that the alteration of behavior, of lack of enjoyment of parkland is enough to confer standing. However, if this court does find standing for the respondents in this case, their claim still fails. The Mount Soledad Veterans Memorial is a moving and culturally significant memorial that recognizes the sacrifices and the cultural heritage of San Diego. And its
What part of
use-
San Diego does it recognize?
San Diego has the largest military population in the United States. It has the largest naval fleet.
But
It
they
has,
said that it's a war memorial for dead soldiers. What dead soldiers is it a memorial to?
it's a memorial for not just dead soldiers, Your Honor, but also those that continue to serve. It's a veterans memorial. There are over 2,000
All veterans?
from World War I, II, the Korean War, and going forward. As it was.
Jewish veterans?
Of course, Your Honor. As you will notice at the memorial, there are over 2,000 plaques, bollards, and
Those
place
were put up
cards.
after the litigation began as a rather convenient response to the litigation that was brought. What about the history of anti-Semitism? To what extent, which the district court never even mentioned in its opinion, to what extent should we look at that and determine that this cross has a very significant context, and that significant context is exclusionary because it's a very blatant sign excluding Jewish war veterans?
As the Ninth Circuit pointed out, it is the obligation of the court to look at the history and context of a symbol. You cannot look at the history and context in isolation and only focus on the behavior of private citizens and color it for the entire history of this particular memorial. While there was a history of anti-Semitism in the 40s and 50s that no longer is present and was no longer present when the United States chose to recognize this as a memorial. Also important with the
But don't
history.
you think that history of anti-Semitism, that the government somehow incorporates that or takes on the burden of that when it goes to the heroic measures that it's gone to in this case to ensure that this cross will continue to be erected, swoops in and takes it over after all of the measures have failed, and it seems apparent that the cross is in jeopardy of being taken down as a result of litigation in which the city has been fighting what seems to be a losing battle? Doesn't the historic context become particularly acute in that regard?
I believe the historical context also takes into account that this court also went to, as you phrase it, historical measures to make sure that the destruction of this particular memorial would not take place without its moment before the court. Justice Kennedy issued an injunction when it became clear that the city of San Diego would have to remove the memorial or face a $5,000 a day
Well,
penalty.
the cross comes down. The two different things here, and the fact that you're equating the cross with the memorial suggests to me that your colleague may well be right in terms of the centrality of that memorial and its problems and tension with the Establishment Clause. The memorial could still exist without the cross, couldn't it?
Yes, Your Honor, but this is not what that is not what the United States chose to accept as a war memorial. What they chose to accept as a war memorial in
It's
their
a
eminent...
Christian symbol so big that you can hardly miss it as you drive down, was it Route 5?
I will disagree, Your Honor, in the sense that just as you must look at the whole history that includes its history as a prominent symbol for the San Diego community, but you must also look at the full context. As this court has held in Lynch, you cannot look at a symbol in its isolation. Otherwise, everything would be an Establishment Clause violation.
Go ahead.
The only thing I wanted to ask you about the purpose, when Senator Sessions introduced the bill, he explained before the floor of the Senate that the whole point was to preserve that cross because it was under attack at the time by the ACLU. So before we look at the context, don't we have to look at the purpose and the explicit purpose of the senator that introduced the bill that funded the omnibus legislation to acquire the property explicitly said it was to preserve this religious symbol, did he?
I do not deny the record, Your Honor, but I do push back and recognize that this court consistently has taken a skeptical view of legislative history to divine purpose in many different contexts, civil rights being one of them. So therefore, instead, I would say another way to look at purpose is also to recognize that the Ninth Circuit found a permissible secular purpose in the eminent domain action.
How can the Ninth Circuit make a factual finding without the benefit of a district court making a factual finding? The Ninth Circuit is not a body of fact finders, but that seems to be, as you point out, that's exactly what they did.
They were, reversing the district court except upholding the purpose argument. I do agree, Your Honor, that there is a factual distinction in the sense that
But excuse me, even the district court couldn't make a factual finding in this case because the district court heard the matter on summary judgment.
With your permission, can I answer the question?
Certainly.
Thank you very much, Your Honor. The district court granted summary judgment. However, both the Ninth Circuit and the district court acknowledged that reasonable men and women could differ about what a reasonable person would see. Therefore, while it is the contention of Petitioner that this is a moving tribute to our historical and religious heritage, if this court should choose, it would be appropriate to remand and ask for a factual finding because reasonable men and women who see the cross and all of the attributes that surround it could see it as a inclusive and well-integrated Veterans Memorial.
Thank you, counsel. We'll hear you again during your rebuttal.
Thank you.
Jeffrey D. Klein on behalf of respondents.
You may proceed.
May it please the court, why should a Jewish woman, when marking the anniversary of the day she lost her child in service to this country, if she chooses to try and turn her sorrow into pride by heading out...
Before we're not dealing with a jury here, before we hear what is, I'm sure, a very emotional and probably a very accurate argument, help me understand why you have standing.
Absolutely, Your Honor. There is constitutional standing under Sierra Club, students challenging regulatory agency procedure, but we don't even need to get to constitutional standing because this case meets the FLAST exception to Frothingham for taxpayer standing. There are 3 criteria under FLAST.
This is a spending clause issue?
Absolutely. Under
How is it a spending clause issue?
Public Law 109-272, Section 2B says specifically Congress is authorizing the spending of any funds necessary, first, to purchase the land, second, to maintain...
purchase or a donation by the city of San
Oh, no,
Diego?
purchase.
Right.
To purchase. And then specific funds to maintain the land in the cross, which are now being given to the Navy specifically to
I
maintain
thought they're
it.
being maintained, that's a separate issue, an agency question, but I thought they're being maintained by a private agency, SMSA or whatever it is?
There's a
MSA?
specific clause in the legislation allotting funds to maintain this site as well. Further, the full faith and credit of the United States is set to pay any judgment against this site.
Well, but if that's the test, then FLAST v. Cohen is gone, because the full faith and credit of the U.S. would always be behind any kind of action.
I mean, the argument you've got to meet is that the defendants in this case say that this was an exercise of the property clause rather than the taxing and spending clause.
Well, it directly invokes taxing and spending in Section 2B of the
So
legislation.
you're relying on the language of the appropriations bill that accomplished the transfer?
Yes, Your Honor, of the bill in question.
Yeah.
In addition, there would be constitutional standing, but if we're accepting taxpayer standing, I can move on to the First Amendment issue.
Well, help me, I'm still stuck with standing. Maybe you can help me a little bit more with that. You're not relying upon agency standings, they're associational standing.
Well, there is associational standing as well under United Food and Commercial Workers. You would have to have 3 criteria. First, a member.
Yeah, and help me with the first one. Where's the member here?
Well, the member has standing under the same taxpayer standing under FLAST.
Who is the member?
Member of the Jewish War Veterans Association who claims...
Does this member have a name?
Minasaga.
Okay. You're not relying upon ISIS declaration then?
But ISIS as well then, Your Honor, I'm sorry.
Wow, okay. I'm not suggesting you should. I think there are problems with ICE.
There-
So you don't want to go down that ICE road. I think there are problems with ICE. All right.
Okay. Thank you, Your Honor. So they would have standing under the FLAST exception to Frothingham as well, and then it's central to the Jewish War Veterans Association's mission to make sure Jewish war veterans are equally represented. So that meets the second criteria, and the third criteria for associational
Well, what is
standing.
specifically, what is the declaration of the individual member of Jewish war veterans that you're relying upon? If, let's take ICE off the table, you're not relying upon his declaration. What specifically is the declaration you're relying upon?
That they would use this land were it not for the cross being on this land, which is similar to the students challenging regulatory agency procedure if we had to go to constitutional standing and injury in fact.
Well, was that because of a religious problem or because, and I'm quoting the declaration now, not of your person, because of ICE? He says he stopped coming to the site because he felt the memorial did not represent him, didn't speak to him, did not know if it is a Christian monument, but it does not speak for me, which I'm not quite sure what that means, but I'm not sure how you get a religious establishment
Absolutely.
problem out of that.
Well, it goes directly to the Establishment Clause. First of all, we would not even need to address that because we have taxpayers standing under FLAS. You don't need injury in fact for that. Second of all, not speaking for them is what the Establishment Clause speaks about. When the government shows it is favoring one religion, when there's a 40-foot tall Easter cross, and this is a Jewish veteran, that cross
Well, he said, I do
has
not
no
know if it is a Christian monument.
Excuse me?
He said, I do not know if it is a Christian monument. I mean, there may well be something there that could be flushed out in testimony, but just on the face of that declaration, I don't know how you can get the kind of individualized injury you need for the first prong of the associational standing test.
Well, the associational prong, we would be able to have the first prong under FLAS as well with taxpayer standing. Additionally, because the cross is something that keeps this person from using the land and their students challenging regulatory agency procedure, it's called aesthetic injury. If someone cannot use a
Yeah, but it would have to keep him from using the land because of some reason that fell within the purview of the Establishment Clause. And I think that the questioning is directed to whether or not ICE's declaration triggers that.
And the fact that it doesn't speak to him, is there a constitutional right to have a relevant piece of land in the middle of the city that speaks to you?
Well, we're having, it's a difference of a preposition. It does not speak for him. As a Jewish person, that person is not spoken for, and that's explicitly what the Establishment Clause is for, so that
But
one
that's
religion.
not what he said. He said he wasn't even sure if it was a Christian monument.
Well,
It just does not speak for him. So if you're right, then we must have a park out there which will speak for Jeffrey Klein, that
As
will
a-
speak for your opponent over here.
Thank you, Your Honor. As this court said in Van Orden, there is no historical significance or meaning for a Latin cross other than as a Christian symbol. So if it was poorly articulated in the complaint, it's still clear. A
Well,
40-foot Easter
let me
cross.
ask you about that, because there's different points of view. I mean, perhaps one person would draw that conclusion, but there's other people that would reasonably say that a Latin cross is also a symbol that is typically used to memorialize the loss of life, particularly for those that lose their lives in the military. In this case, it seems to me that the problem is that the district judge made this factual finding that identified a Latin cross with a religious purpose, and it was not his function to do that. It was his function to view the evidence in the light most favorable to the government.
Well, Your
Not
Honor,
to you.
it's this court's holding, and there is no historical significance for a Latin cross other than as a Christian symbol, and it's not used as a universal symbol in war memorials. That's simply not the case. In Arlington National Cemetery, to represent everybody, we have the Tomb of the Unknown Soldier, which is a flame. And in particular, if we look at the context of this cross, it was put in the spot it is because it was the perfect spot from which to showcase their Christian faith. It was dedicated to their Lord and Savior Jesus Christ, dubbed a gleaming white symbol of their Christian faith, and there was not one, as the Ninth Circuit noted, not one indication it had anything to do with veterans or memorializing anything other than Jesus Christ.
What about the
until after this
Stars of
litigation
David
began.
on the placards that memorialize the loss of life for Jewish veterans?
We're dealing with two separate things. Not only were those put,
Well, why don't you answer his question, then deal with the one you want to answer?
no, I'm absolutely answering
In
your
other
question.
words, there's a plurality of religious views
There are now
that are
2,100
memorialized.
plaques there, Your Honor, and that's what I'm addressing. There are two separate things on this site now. These plaques which were put after the litigation began, and some things that maybe somehow relate to a war memorial. And then there's this Easter cross, which still stands separately. It's even walled off from everything else. And as this court said in Allegheny County, you can look at things differently based on the context. So in Allegheny County, you had a menorah, a religious symbol, and a Christmas tree. And those were found not to violate the Establishment Clause, while at the same time, a nativity scene was. Why? Because it was given more prominence and front and center. And in this case, some tiny plaques that have various equal-sized religious symbols, we are not challenging those. On the other hand,
What test should we use?
whether you use the Van Orden test or the Lemon test, they both look at the context, they both look at the history, and the purpose was mentioned, and I do believe the Ninth Circuit could have found that this did not have secular purpose. If you do look at the congressional record, as you said, Senator Jeff Sessions from Alabama, when he introduced the bill, said the purpose is to save the cross. And
Well, who do you think he was speaking to? Do you think he was speaking to a court of law as to the real legal purpose of the bill? Or was he pitching it to his constituents for when he runs again? I mean, to what extent can a single statement of a senator on the floor of the United States Congress have much significance in terms of the meaning of legislation?
Well,
we
Your
know
Honor,
why he made the statement.
Absolutely, and there's much more than one statement, and that's where I think the Ninth Circuit, there should have been more factual finding. If you look at the House record, Congress...
So it shouldn't have been summary judgment, is what you're saying?
If this court, it's summary judgment enough on the effects prong, which is how the Ninth Circuit found that this violates the Establishment Clause, but it's even a stronger case, and if for some reason this court were to have question, then it could go back down for more fact-finding for the purpose prong, because it wasn't a secular
So you have no
purpose.
problem with us vacating, well, it wouldn't be vacating, actually. Well, it would be, because we'd be going back down to the
Well, no,
to the
I
district court.
absolutely would not prefer that. I would prefer that if you, over a holding reversing.
But we understand you'd prefer to win. That's why you're being paid to make that position.
But,
You would have no problem with us saying, basically, this is not appropriate for summary judgment, vacating the Ninth Circuit and sending it back for
Well, it is
fact
appropriate
finding.
for summary judgment. What I was saying is the case is even stronger than the
Why,
Ninth
why
Circuit.
is it appropriate for summary judgment? You've got two competing sets of experts here. The district court, in its opinion, talks about, though it grants summary judgment, talks about the factual disputes before it, and then resolves those factual disputes. Why in the world would not that be something that should go back for a trial as opposed to a ruling on summary judgment?
Well, as both sides have moved for summary judgment, they both acknowledge there are no factual disputes.
Yeah,
In
but
particular-
does the fact that both sides have moved for summary judgment have any significance as to whether the case should have been decided on summary judgment?
Well, in this case, I think both sides were correct, Your Honor, because there are no questions of material fact with regard to the Easter cross, with regards
There's
to
no
its history.
questions of historical fact. The inferences from those facts are greatly in dispute. For example, you touched on the secular effect or the religious effect of this cross that is 29 feet tall in this high point of the city. Well, the Ninth Circuit, ourselves, we don't know how that will contrast with the 2,100 placards that represent other religious views. But it seems to me that the problem is that the Court of Appeals simply engaged in fact-finding, interpreted the inferences from those historical facts in a way that it was not suited to do.
Actually, Your Honor, the Ninth Circuit Court of Appeals simply followed precedent. If we look at separation of church and
Well,
state
that doesn't
committee-
make much difference if the precedent is wrong,
Well, it looked
or
at...
if it's misapplied.
Well, if I might cite some cases, Your Honor,
Yeah.
separation of church and state committee, Ninth Circuit, Ninth Circuit, ACLU versus Rabin County, 11th Circuit, Gonzalez versus Northern Township of
What are you
Lake County,
citing these
7th
cases
Circuit.
for?
These are all cases in which a cross like this, even when it's been dubbed a war memorial, has been found to violate the Establishment Clause. And I might note petitioners have not presented a single case, not one, in which a cross like this has been examined and not found to violate the
The Ninth
Establishment
Circuit said
Clause.
there are no other crosses like this. This is sui generis. There are no other situations, no other memorials where you have a cross like this, which goes into the merits of your argument, but I'm not sure it helps you in terms of summary judgment. If the test is a reasonable observer's conclusion, doesn't that almost require ipso facto some kind of factual determination, like
Well-
the reasonable person in torts? That's not a question of law, it's a question of fact.
No, we would be scant to have summary judgments if we did. And in a case this clear,
There's some people who argue that maybe we do have too many summary judgments, and the right to a jury trial is just that, it's a right to a jury trial.
Absolutely, and if there were disputes, if this were not a 40-foot tall Easter cross, and if I may, when we're addressing the issue, it's very plain. There's an expression in medicine. When you're trying to determine what something is, if it looks like a horse, don't try and make it into a zebra. This is a cross
And
atop
I
a
assume
hill.
that medical expertise is on the record.
It is, Your Honor.
It is, okay, all right.
It's a standard teaching. And here you have a cross atop a hill. There are other examples of this still throughout the Southland. If you go up to Glendale, as you drive east on Brand Avenue,
And this is all on the record?
with these,
Or is this fine on zebras?
these are examples of other crosses atop a hill similar to the ones we're dealing
But
with.
where are they coming from?
They're coming from
Client on zebras.
perhaps judicial notice as general facts,
All right.
if I may, because they're very
I'm
well
not
known.
sure you may, but you're trying. Go ahead. All right.
There is a cross atop a hill in Glendale.
Let me, you don't have much time left, let me switch you to something else. We've been talking about reasonable observers.
Yes.
What's the vantage point we should be looking at a reasonable observer in this case? Because I suspect that this memorial looks quite different from the interstate highway where you can't see anything but the cross, and from 10, 15 feet away from the cross where you can see and read these other plaques and bollards.
Well, as this court has said in Van Orden, it's a reasonable observer aware of the context and history. A reasonable observer would
But
be
that doesn't
aware
tell
of
me
anti-
which reasonable observer, because you're going to, you at least have the prospect of contradictory results depending upon what the vantage point is of the reasonable observer.
Well, the reasonable observer would know the history of anti-Semitism that has been mentioned on this bench. They would know the history of events, which did not include one
So
secular
you're
event.
telling me the vantage point doesn't make any difference?
Can you repeat the question, Your Honor?
Yeah, all right. You've asked us to look at what a reasonable observer would conclude. I'm asking you where the reasonable observer would be located, because we've got a memorial here that looks completely different or materially different from half a mile away than it does from 20 feet away.
Well, with all due respect, Your Honor, it doesn't look that different. What we're dealing with, it doesn't look that different. What we're dealing with here are two separate things, as in Allegheny County. We have some things that have been put down since this litigation began that may resemble a war memorial, and then we have the Easter cross. There's not one word in this legislation that says the cross has
So
to stay.
I don't understand. Are you telling me that my question makes no difference, or that you just don't choose to answer?
Well, I'm saying
Or
no
both.
difference.
Or
I'm
both.
saying whether you view it up close or whether you view it from afar, it's a 40-foot Easter cross that we're dealing with. And
Okay.
it's overwhelming and violates the Establishment Clause.
But that's a nice conclusion, but why and how do we get there?
Because if you look at the history and context, this has been used for nothing but Easter services until this litigation began. It
My
now stands
understanding is since
separately.
they put the big cross up, the one we're talking about, there have not been any Easter services. There have been some memorial services, very, very few, but there have not been any uniquely religious services. Am I wrong about that?
That's wrong. This was put up in 1954, dedicated to Jesus Christ, called a gleaming white symbol of their Christian faith. Not one symbol was put up having to do with memorials. It was put up during an Easter sunrise service, and Easter services were held every single year, while not any secular services were held, Your Honor.
And the government didn't own that property.
Absolutely.
Ergo, there was not a violation of the First Amendment. Since the federal government acquired that property, there hasn't been any Easter services, has there?
Religious services continue, and I might want to,
Wait, that's an important question. You're saying they have been
Religi-
continued after the government took
according to
possession
the
of the
Ninth
property?
Circuit, holding religious
Well, what about the
services still
district court?
continue.
Because the district court's concern was imputing what happened before with the motives of the federal government. So according to the district court, after the federal government took possession, there were no religious services, and even went so far as to say the motivation of the private parties ought not to be imputed against the federal government.
I would like to discuss the congressional record where it speaks to Congress's motivation in this.
Could
Because-
you discuss my question in the middle of that? Because my reading of the district court's opinion would be consistent with what Judge Bachrach just asked you, that since the federal government took it over, there have not been any religious services
That's-
that weren't allowed.
That's not accurate according to the Ninth Circuit.
Well,
Religious services-
well, then identify for us what religious services have taken place since the government took it over.
I believe the Easter services have continued, but the Ninth Circuit said specifically that religious services continue at that site through
But the
today.
question was, identify for us what religious services.
I don't have a specific date.
Yeah.
at this point.
And so you're asking us to take, as a matter of fact, not something factual in the record, but what the Ninth Circuit said the facts are, because the Ninth Circuit, in terms of recent Supreme Court jurisprudence, has proven to be infallible, right?
Unlike the third.
They may or may not have been, but even without events there, the history and the context, and this was brought up on the floor of Congress by, for example, Congresswoman Susan Davis. She and others raised issues about this cross, and what the congressman who introduced this legislation, Congressman Duncan Hunter, said was, we know we have this issue about the cross. Let's go ahead and vote for this as a war memorial, and then it could come before this court and you can bring your attacks. The purpose of this is clear. There was no reason to have legislation to save anything resembling a war memorial. The plaques were never under attack. The city of San Diego would have maintained them. There was absolutely nothing that was in jeopardy except an Easter cross with no secular history whatsoever. Any events that may occur now may occur in relation to the plaques. If you're talking about secular events, what we have is an Easter cross on government land. The purpose of this was...
Keep calling it an Easter cross. Well, the courts have called it
was
a
referred
Latin
to,
cross.
Well, it was referred to as the Easter cross on local maps. And it was dedicated during Easter sunrise services. And every year throughout its history, at least up through the year 2000, there were Easter services there every year, and never secular events. So if I may, with my final minute, Your Honor, there are examples of this throughout the Southland. This is
Examples of what?
of this cross atop a hill. This does not resemble, does not have any symbols on it that relate to being a war memorial. Its history and context make clear it's not a war memorial. It's a 40-foot Easter cross, as it was referred to on maps, dedicated to Jesus Christ. And as the lower
Did the
court
federal
correctly
government
held,
make those maps?
excuse me?
Did the federal government make those maps?
No, local people made the map showing what a reasonable person would consider it to be. There would
No,
have been no
that's a big jump. You're saying local people made the maps showing what a reasonable, how you get there.
Well, this is what it was referred to locally. That's why it was put that on the map. So it was considered an Easter cross to the community. And as the lower court correctly held, there is standing in this case as well. So to finish up, respondents would simply request that the lower court holdings are upheld, that there is standing, and that this Easter cross does violate the Establishment Clause.
Thank you, counsel.
Thank you, Your Honor.
Petition is reserved rebuttal time.
Yes, thank you, Your Honors. Opposing counsel has pointed out the observation that he
Before we
believes...
go to what he pointed out, you'd mentioned Lynch when you were here before,
Yes.
and maybe you can help relate that to what Mr. Klein has argued. Correct me if I'm wrong, but in Lynch, they had all kinds of things that were part of this display. An elephant, I don't know how you get an elephant into a Christmas display, but maybe it was a reindeer made by a committee, I don't know.
First of all, that happened in Rhode Island, and it wasn't the Christmas display. That was the point. It was a holiday
But
season
you got an
display.
elephant, you got a Santa Claus there, all kinds of
Yeah.
things. And you did not have one overtly identifiable religious symbol that was any greater. In fact, it was rather insignificant when compared to all of the other stuff that was jammed into that display. Here you have an incredibly significant, overpowering, if you will, cross. Given that difference, how does Lynch help you?
To begin, Your Honor, I would disagree at the idea that this cross is overwhelming. I would not disagree that it
How
is
much does it
significant.
weigh?
The weight, yes, Your Honor, is in tonnage, but
How
so
tall is it?
it's 29 feet tall, Your Honor.
29
However,
feet tall, 40 feet, 40 feet tons, that's
yeah.
not overwhelming?
However-
How far away can it be seen from?
it can be seen from the roads below. However,
How far
Can
away?
anything else in this so-called memorial be seen from the road below?
no, Your Honor, but a reasonable observer must see it in its full context to be able to make a determination.
Well, from what you just said, you can't see it in its full context, so all you can see is this 43-ton cross.
Therefore, those who see it from the road would not be considered the reasonable observer. The reasonable observer must know its context
Well, you can
and its
argue
history.
that if they're driving on the highways in California, they're not reasonable. You can make that argument. But
Every day, Your Honor.
why are you saying that the people who see it from afar are not the reasonable observer? They don't become reasonable until they get closer. And if that's the point, at what point does reason find them? Is it a mile away, 2 miles away?
In order to be able to understand the memorial in its full context, one must be able to see the over 2,000 plaques, the plaque designating it as a veterans memorial, and understand its full context and history. as to bring back your point about Lynch, the reason why the crash in Lynch was considered secular is for the fact that, yes, it had the surrounding
Stuff,
aspect.
which is all kinds of stuff. was
However,
tossed
but
in
it
there.
also acknowledged that the crash has religious significance, and that can be on federal property, in the same way that a memorial here can be on federal property.
Of course, the crash in Lynch wasn't on federal property, was it?
Excuse me, government property. I misspoke, Your Honor.
Okay.
However, much like the display in Lynch, you saw a religious symbol that had undeniable religious connotations, but it also had a history of becoming more
The difference
secular.
there, though, is that the religious symbol in that context had a very secular context as well.
Correct, and
I'm not sure the same is true of a cross.
I would disagree, Your Honor. The Mount Soledad Memorial, which includes a cross, has a secular meaning for two reasons. One being the fact that, as this court noted in Salazar v. Bono, a white cross has the ability to elicit thousands of small crosses across battlefields around the country, and the importance of never forgetting
Small
their.
crosses.
However, one cross can embody thousands of them, is what your colleagues on this particular court noted in
So you're
Salazar.
saying that this gigantic cross, if I can use that term, is okay because it's a lot of little itsy-bitsy crosses. And so, since Arlington and places like that, we have the poem that was referred to by McCrae, the Fields of Flanders, since a lot of little bitty crosses are okay, you can aggregate them all and have a 43-ton cross that can, as you drive down Highway 5, is all you can see, but it's okay because it's really just an aggregate of a lot of little crosses. That's what you're arguing.
As you pointed out, Your Honor, this is a unique memorial. Of course, I cannot point to an exact case that is similar to this. I can point to Salazar, which did, while you could not address it on the merits due to statute of limitation reasons, you did note that a cross on federal or state property is not per se unconstitutional. And for a particular monument like the Mount Soledad Memorial, which has had historical significance in the San Diego community for 100 years, including in
But that doesn't help you
1954.
because part of that significance is a symbol against the Jewish members of the community. It's very clear from the Ninth Circuit's record. Again, the district court didn't bother to get into any of that, but that is part of the significance of the cross in that community, and that runs you right into the Establishment Clause.
It is also significant for the thousands of veterans and thousands of men and women who live in San Diego that visit the cross on a daily basis and see the memorial in its full context and chose to buy a plaque there, which is one reason why it is important to recognize that history is not
If what you're
static.
saying is right, why not, except for the fact of principle or abstinence, just remove the cross? If the cross is not central to the memorial that you have there for veterans, why not just remove the cross and have the bollards and the plaques? You haven't lost anything if what you're saying is true.
With permission, Your Honor, can I answer?
Certainly.
Thank you, Your Honor. This court, one of your colleagues, Justice Kennedy, pointed out and therefore issued an injunction that stayed the removal of this particular cross because of the hostility that it would show to our veterans who do believe that this is a valid and
But that
moving
wasn't a court
tribute.
decision. He just issued that injunction.
Correct, Your Honor.
Right.
But the removal of this symbol would be hostile to religion and hostile to this court's previous holdings in Van Orden, in Marsh, that history has significance and that it is not static. Religion has significance in our being, and therefore, for that reason, we ask that you reverse the Ninth Circuit, grant summary judgment for Petitioner, and hold that this is a constitutional Veterans Memorial in La Jolla, California. Thank you.
Thank you very much, Counsel. Thank you both. We'll take the matter under advisement.
If we could just take a really quick moment, this competition would not have been possible without the contribution of a great many people. I just want to take a very quick moment to acknowledge them. Is that better? Okay. So just to begin with, we want to thank the sponsors of the event, Experian and Jones Day. We definitely want to thank our own Dean Chemerinsky, whose vision for this competition is as a student-run enterprise that will really be one of the core institutions here at UCI, and who's always made sure that the board members have all the tools that we need to succeed. We want to thank the coaches who volunteered their time to help train the students who competed this year, including Senator Dunn, Professor Trilby Robinson-Dorn, and Professor Hoffman. We want to thank our faculty advisors, Professor Robinson-Dorn and Professor Krosky-Roberts, who are very generous with their time and helping us make sure all the details were covered. We want to thank the faculty graders who graded and regraded all of the briefs that were written this year, probably totaling thousands of pages. That's both Professors Robinson Dorn, Croskery Roberts, Ross, Weinstein, Asher, Zinner, Hempel, Solomon, and Kay. We want to thank Brittany Rodriguez, who tireless work really meant the difference in all of this coming together, and who's really someone who's always willing to go the extra mile for students. We want to thank the panel when they come back, but also the more than 50 judges and appellate attorneys who volunteer their time to judge the other rounds of this competition. I really want to acknowledge the board members who are 10 students, all third-year students this year who participated in the competition last year, who donated countless hours of their time to organize this year's competition and also really helped to develop this as a core institution here at UCI. Could I ask those folks to stand up? I have to put you on the spot. And then finally, we want to acknowledge all the students that participated in the competition this year. And I'd just like to say that observing many of the arguments this year really kind of reminded me about one of the things that's best about UCI, which are students whose incredible talents and dedication are matched only by their professionalism and collegiality. So I think you all deserve a round of applause. Thank you.
So we're going to actually recognize each participant by name, and I apologize in advance if I mutilate any of these names. It does not diminish your performance whatsoever. And when you hear your name called, if you could please come up, and our lovely dean will be handing you your certificate. So first, we have Jeffrey D. Klein. Corey Lovato. Adriana Nunez. Nancy Rojas Hill. Andy Smith. Lisa Petak. Adam Berry. Serena Wu. Sahara Nasiri. Dan Schieffer. Kevin Chi. Leanna Costantini. Al Trudeau. Jacob Barrick. Hank Hymanson. Lauren Gruber. Lauren McKay. Kelly Suck. Nick Hartman. Brooke Weitzman. Evan Sipple. Darren Kirstein. Tim Martin. Erna Mamikonian. Dexter Rapley. Andrew Bernard. Nicholas George. With this many names, you might wonder if everyone in the entire school participated. Amy Meyer. Casey Reagan. Katie Perucci. And last but certainly not least, Andrew Cantor.
It's now my pleasure to help, Dean, please, you don't get to sit yet, help to present the awards for Best Brief. As I'm sure the judges would acknowledge, were they here in any argument, certainly at this level, the briefing is absolutely critical, if not paramount. So it's with great pleasure that we give out these awards. The students write in teams of 2, as opposed to how they're arguing here, so that's how we will recognize them. And this year we've had a tie for runner-up after we graded and regraded. They were still tied, and we're so honored to be able to present 2 teams with the runner-up. The first is the team of Evan Sipple and Lisa Peacock. Also tied for runner-up, the team of Tim Martin and Serena Wu. This year's Best Brief team, Nancy Rojas Hill and Nick Hartman.
Okay, thanks.
Okay, great.
You may be seated. Thank you all for your patience. There was a reason for our deliberations, and the reason was that we found both of these advocates to be superb, and it was very difficult to choose between them, even for 3 people whose professional life consists of making decisions. But we have made a decision. Let me take advantage of a moment of suspense, though, and before I get to that, make some general remarks that come from all of us. First, I want you to stop and reflect on the diversity of the panel that we have here. you have one of the most distinguished appellate jurists in the country, in Chief Judge McKee of the Third Circuit. And you have a man who is widely touted as perhaps the rookie of the year in the new judge from the 10th Circuit, Judge Bacharach. The three of us represent a wide geographic swath and a wide generational swath. I was appointed by President Reagan. Chief Judge McKee was appointed by President Clinton. Judge Bacharach was appointed by President Obama. And a panel of this diversity could only be assembled by someone like Dean Chemerinsky. The thing that all of us have most in common is our admiration for the dean and the sense of indebtedness that the Article III judiciary has for everything that Erwin Chemerinsky has contributed to our store of knowledge over the years. And we are all marveling at what he and his team have done in such a relatively few years to transform this raw acreage into a real vibrant law school. And it's a pleasure for us to be a part of that here with you today.
I second that motion.
I don't think we have any dissenters.
I third it.
I also want to say that at least between Chief Judge McKee and myself, we have presided over more moot courts at more law schools than the Mount Soledad monument has square inches. And we have not seen a better set of materials given to the incoming judges than the executive board of the Moot Court Competition prepared for us to assist us in these arguments. So I'd like you all to join with me, and let's give a real round of applause to the Moot Court. Now, that said, I have the privilege of announcing the outcome of our deliberations, and then I'm going to ask first Chief Judge McKee and then Judge Bacharach to comment a little on what we observed and saw during the arguments. It is our decision, and I want to emphasize again that it is as close as it could be, that the award for the best oralist should be given to Lisa Bisak.
Yeah, first of all, let me also follow up on the comment about the bench brief. They really was phenomenal. The materials were, and it's not easy to do that. And I want to echo what Judge Salya said. The other thing that Judge Salya didn't say about your dean is that it's almost impossible to say no to him, which is why, the diversity is here on this bench. Let me start with Lisa. You did something which I was almost like Heifetz on the violin, and that was the way you segued from the standing argument into the merits of your argument. And you did it with a question. I think I was the one who asked you the question. And you took that question. I don't know if it was because you were getting beaten up on standing, because it's a difficult argument for you. But you took that question, answered it, which is important, and then segued into your merits discussion. And you got us all then off of standing and into the Establishment Clause, which is very smoothly and very expertly done. I wouldn't expect someone in law school to be able to do that. It was really extraordinarily well done. Your real positive attributes are, and this sounds trite, but it's not, you listen to the question and you answer the question that was asked. And most people do not do that. I'll tell you a little story, I'll be quick. We sit in different parts of our circuit. We have a panel in Newark, New Jersey, and a panel in Pittsburgh, Pennsylvania. I was on the very first panel to sit in in Newark. And I was there with Judge Greenberg and now Justice Alito. And there was an attorney arguing who was so good at just listening to the question that Sam stopped and said, you know, you have a remarkable quality, and that is you listen to our questions and you answer our questions. And then both myself and Mort said, yes, that's right. So it's not that common to see. I don't know what this means. I had down here avoid response, deny them the use of. And a couple of times I think you said that, and I'm not sure you need to say that you're denying them the use of, that you have to concede that. The way you said, I would disagree, I thought was very well done. You can say, and it gets obsequious after a while, I respectfully disagree. I don't think it's a big deal that you don't say that because it does get obsequious. The way you said, well, I will disagree and not concede something that you didn't have to concede, I thought was very, very positive. Mr. Klein, your use of the public law here was very, very good. I mean, you took our questions, you wedded it to the legislative text, and then came back with us with the bill that you were basing your argument on. So it wasn't just your argument, you were relying upon what Congress had said. And I thought that was very strong. The one thing I'd caution you on, and we kind of got into this exchange a little bit, keep your argument on the record, even though this is a very artificial construct, obviously. You have to be sure and be careful that you limit your answer to what's on the record. And if you have to go outside the record, say something like, well, Your Honor, it's not on the record, but if I may, and then proceed to answer the question. The other thing, avoid saying absolutely in answer to the question, because a couple of times I think you said that you're so anxious to get the answer out that in saying absolutely, you conceded something that you probably shouldn't have conceded, but you simply, the question was there, didn't quite get all the way out, you said absolutely, and then moved on to your point. But I thought, again, your arguments were really incredible. I'm not sure I've ever seen two arguments, and whenever I do a final Moot Court now, whenever I do a Moot Court, it's always a final now because of the chief thing. I don't think I've ever seen two applicants or litigants, whatever you are, arguers, who were as good and as close as the two of you are. You're really incredibly good. And I feel privileged to be here to preside over your arguments. You both did an incredibly wonderful job.
Judge Bacharach?
As the other judges said, for me, it's really a great honor to participate in this wonderful event with your school. It's a great institution, obviously led by a wonderful person and a wonderful dean, and it's I really cherish the privilege of being here to participate with you all. And at the risk of being repetitious, I do want to comment. I didn't realize that the other judges had the same observation that I did, and I commented to one of the board members on the way over here that I assumed that that the bench brief had been done by your dean. I didn't realize that it had been done by students. And
it's either bringing him down or bringing you up.
It's bringing you up, I assure you, because they really were extraordinary. I haven't done as many moot courts as these fine judges, but I've done a fair number, and it really was the best bench brief that I have seen as a participant in moot court. And it absolutely, as Judge McKee said, and again, I haven't done as many as Judge McKee has, but I've done a fair number of moot courts, and both of you just were extraordinary advocates. I'm sure, Mr. Klein, you're probably a little disappointed, but you made second in the finals of this moot court, and you are already an extraordinary advocate. I was a law clerk for another judge in the Court of Appeals and made a number of Court of Appeals arguments myself and have seen a number of them. And I can tell you unequivocally that both of you are stellar advocates already, and both of you will have extraordinary careers in front of you. I was a little bit astonished when Judge McKee observed how well both of you did in answering questions, how well both of you did in doing that, because I think, frankly, it's clearly the most important attribute of oral argument, and it's the most difficult. And I would imagine particularly when you see hundreds of your classmates and family members in this beautiful room, because you've got to be, if you're a human being, as nervous as can be. And when you're nervous, it is hard to listen. And both of you did. And to make it a little bit doubly impressive, these guys asked you incredibly difficult questions. And I thought, my gosh, I'm glad I'm not down there. But you both did just an amazing job. The only, it's really not a suggestion, because I don't think you need suggestions from me, but one thing that helped me a little bit, maybe to combat nervousness and maybe to make sure that I heard the question properly, is maybe just to take a moment when the judge asks a question, just to make sure that you've heard it, and so then you can articulate your answer. But truly, both of you just did an extraordinary job. That's it.
Well, with that, I think it's time to go party. We stand in recess.
Before you leave,
Yeah.
I get the pleasure of concluding the program by expressing appreciation and handing out the awards to the finalists.
Okay.
Let me begin by giving some thanks. First, I want to thank Experian and Jones Day for the support of the program. My vision of law school from the beginning was to have a very vibrant Moot Court program, because I really believe it's superb training for our students, not just in appellate advocacy, but advocacy more generally. And from the very beginning, Experian and Jones Day have provided the financial support for the program. I particularly want to thank Scott Leslie and Tom Lay and ask them to stand. They're from Experian, and they have been the driving force in supporting the Moot Court program each year. Second, I want to thank the Student Moot Court Board. Moot Court here is a student-run activity. As the judges pointed out, it's the students who prepared the record. It's the students who wrote the bench brief. It's the students who arranged the preliminary rounds. It's the students who got the judges for the preliminary rounds. And truly, every detail of the competition was taken care of the students. And if I could again ask all the students on the Moot Court Board to rise so you can thank them. Third, I want to thank the faculty advisors to the Moot Court program, Rachel Krosky-Roberts and Michael Robinson-Dorn. Thousands of questions seem to arise over the course of the year where they need to be involved in giving guidance to the students and helping. And they've always been there. So Michael, Rachel, thank you so very much, and let's all recognize and thank them. Finally, I want to express my heartfelt thanks to the three judges. As mentioned, they've come from all over the country, from Pennsylvania, from Rhode Island, Oklahoma. I've had the pleasure of knowing each of them for a long time, and I can tell you the reason they were invited is they are three of the very best appellate court judges in the country, and we certainly saw that here. I have a small gift for each of you. Well, try to jump on the stage, but it's really just a token of appreciation for you making the trip here, and you're making our Moot Court final so very special. Please join me in thanking these three wonderful judges. And of course, most important, please join me in recognizing Jeff Klein for second place in a superb performance today. And finally, first place, as you know, this is anticlimactic, goes to Lisa Petak. And for this, you get a plate, and also we have a permanent trophy that sits in the Mark Robinson courtroom, and your name will be inscribed as the winner of the 2013 UCI Moot Court Competition. And now
Don't blow it now, Lisa.
And now we can do what Judge Salia said, to party. There's a reception outside. Please join us.